Hey guys, this is Tommy with Tommy Nation Politics. How's everyone doing today? Tommy Nation Politics.
Corporations are people, my friend. We can raise taxes, and of course they are. Everything corporations earn ultimately goes to people. So, where do you think it goes? What? Whose pockets? Whose pockets? People's pockets. Okay, human beings, my friend.
In the Supreme Court case of Citizens United v. Federal Election Commission, the court's ruling basically freed corporations and unions to spend as much money as they want to elect or defeat candidates, as long as they didn't contribute directly to the candidates or political parties. The majority also argued that First Amendment protects associations of individuals, not just individual speakers. So you can't prohibit speech based on the identity of the speaker. So, now corporations have free speech rights, just like you or I. The idea of corporate personhood, or the legal notion that corporations share some of the same legal rights and responsibilities held by individuals, had pretty much been established by the Supreme Court since the 1800s. In this case, the court definitely ruled that corporations are people. Corporations are people. That means they establish justice, promote the general welfare, and secure the blessings of our liberty and our posterity. Wow. Justice John Paul Stevens led the opinion of dissent. Stevens was pretty upset about how this one turned out. His dissent was 90 pages, and he passionately summarized it for 20 minutes from the bench. Stevens later wrote a book explaining that a constitutional amendment should be passed to make sure money doesn't influence politics, mostly due to this ruling. Today, Citizens United v. the Federal Election Commission continues to get people fired up. If we're going to maintain a true democracy in this country, it is absolutely imperative that we overturn this disastrous Supreme Court decision. Hey guys, this is Tommy with Tommy Nation Politics. How's everyone doing today? A letter from James Madison to James K. Paulding, March 10th, 1827. Dear Sir, I have received your favor of February 28th and read the pamphlet under the same cover. It is a powerful and a piercing lesson on the subject which it exposes. I was not before aware of the abuses committed by the lawmakers and lawbreakers of your state. The picture you give of both, though intended for New York alone, is a likeness in some degree of what has occurred elsewhere. And I wish it could be in the hands of the legislators, or still better, of their constituents everywhere. Incorporated companies, with proper limitations and guards, may in particular cases be useful, but they are at best a necessary evil only. Monopolies and perpetuities are objects of just abhorrence. The former are unjust to the existing, the latter usurps the rights of future generations. Is it not strange that the law, which will not permit an individual to bequeath his property to the descendants of his own loins for more than a short and strictly defined term, should authorize an associated few to entail perpetual and infeasible appropriations, and that not only to objects visible and tangible, but to particular opinions, consisting sometimes of the most metaphysical niceties, as is in the case with the ecclesiastical corporations. With regards to banks, they have taken too deep and too wide a route in social transactions to be got rid of altogether, if that were desirable, in providing a convenient substitute to a certain extent for the metallic currency and a fund of credit which prudence may turn to good account. They have a hold on public opinion, which alone would make it expedient to aim rather at the improvement than the suppression of them. As now generally constituted, their advantages, whatever they may be, are outweighed by the excess of their paper emissions and the partialities and corruption which they are administered. What would be the operation of a bank so modified that the subscribers should be individually liable, pro tanto and pro rata, for its obligations, and that the directors with adequate salaries paid out of the profits of the institution should be prohibited from holding any interest in or having any dealings whatever with the bank, and be bound moreover by the usual solemnity to administer their trust with fidelity and impartiality. The idea of some such modification occurred to me formerly, when the subject engaged more of my attention than it has latterly done. But there was then, as there probably is now, little prospect that such an innovation would be viewed with public favor, if thought by better judges to have pretensions to it. Mrs. Madison and myself value too sincerely your kind sentiments and recollections, not to be gratified by the manner in which you have expressed. In the meantime, accept and offer to Mrs. Paulding our cordial salutations. Sincerely, James Madison.